car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome into the attorneys, and thank you for being with us each Sunday night. It's been our great privilege as a law firm to be able to answer questions here for you each Sunday night on WVTM, issues that you may face in your life. The show is always better, as we have said for many years, when you get involved. We are here. We have lawyers standing by right now for a free, off-air, confidential conversation related to tonight's topic and other topics. Along your screen throughout the night, there will be a phone number and a text number that you can always reach us at. In addition to that, we're always available on social media, Hollis, Wright and Clay on Instagram and Facebook and on Twitter. So to the extent that you've got questions or issues, you can hit us up on that too. Tonight's topic we're going to be talking about is the topic of divorce and how to work your way through if you find yourself in a circumstance for the need to have a divorce. Caleb Faulkner is with us tonight. And Caleb, first of all, welcome to the show, and thank you for coming in to talk about this very pertinent topic.
Thank you, Josh. I'm glad to be here.
Absolutely. And tell us just a little bit about kind of how you got into this area of the practice, and kind of also a little bit about your firm and what you guys do.
I started as a third-year law student, started clerking with the firm of Boyd, Fern & Buchan Dunn, where I am now. Never thought I would be a divorce lawyer, but have enjoyed every minute of it. Found it through an opportunity looking for a clerkship. Clerked that year, and I've been practicing in divorce law with Boyd, Fern & Buchan Dunn ever since. So
I know we get a lot of people that have questions that will text or call tonight. Yeah. I am assuming that a lot of times you're dealing with individuals at kind of an emotional, both physically and mental time in their life, where you almost have to serve in a counselor role to kind of assess how to manage them and handle them through a divorce process.
Absolutely.
Yeah.
Absolutely. Our firm was founded in 1987, and we handle primarily divorce and divorce modifications. And obviously, a modification is any change to a divorce decree following the decree. Maybe 6 months later, it may be years later. We also handle family disputes, out of wedlock custody support, paternity matters, as well as adoption. So there's absolutely a lot of emotions that run through the gambit on all of those issues.
Tell me, just what are some general recommendations of things that people need to look for when they're trying to hire someone to consider a divorce?
Well, I think the first thing that would be good is ask around. Ask people you trust who have used somebody, who know somebody. It's our experience in any practice of law and in business in general that word of mouth reputation is normally the way to go. Looking at a nice website, you don't really know the reputation, the history behind it. And so that's the first thing I would say. The second would be just recognize that you do need a lawyer during this time. Like you mentioned, Josh, it's a very emotional time. Yeah. And, you know, any of us, and I would be the same, going through that period of emotion, we're not always the best judgment. We're not always looking at things logically. And we need to hire somebody who can step in, have the requisite experience, the temperament, and the neutrality to step back and be able to be objective and to assist during that time.
Do you find yourself sometimes meeting with a client where you recognize the client is either not prepared for a divorce, or maybe there are alternative ways to resolve the conflict in the relationship and divorce is not the answer to it, where you're giving advice on that front too?
Absolutely.
Yeah.
And trust me, I love it when spouses do reconcile and are able to overcome those issues. And we certainly have cases where a divorce is filed and it ends up being dismissed, and that's certainly great.
Do you guys provide, and I know the issue of cost and expense always comes in, it comes up in our world too at Hollis Wright. I'm assuming that's something that's not taboo, that someone can ask you about those issues of what is the cost, do I have the ability to have a free initial consultation, those types of things. Are those things you kind of work through with clients?
It is. We tell a client up front what the expectations are financially. We do charge a consultation fee. It varies by attorney, but it's not an exorbitant consultation fee. And when we bring them in for the consultation and assess the case, that's when we'll quote a retainer. Okay. We'll explain our hourly rate and how the retainer works and what comes out of that retainer.
I have found in my practice that talking about how our process works is going to put a client at ease to recognize, okay, hold on, I can handle this, I can manage this. Yeah. Just knowing and understanding and having information related to payment, consultation, those types of things makes people feel a lot more comfortable. I'm sure you see the same thing.
Absolutely, and that's the number one purpose of the consultation is to get them in there and just make sure everybody's on the same page. Make sure they know the process that they're entering into. It's a hard process. It's a process people don't want to enter into. Make sure they understand. Make sure they understand the law and how that compares to their expectations throughout the process, and obviously payment and time.
Yeah. So if someone's going to come for an initial consultation, are there things generally you want them to bring with them or to be prepared to discuss with you to kind of start assessing the best decision for them?
Absolutely. So as far as bringing anything, if an individual has been served with a complaint for divorce, we need that complaint. We need any other motions they were served with. If there's an ex parte order or an ex parte motion for relief without a hearing that a court has granted, we need to see that. We need to see anything that individual has been served with. If that individual has not been served and they're seeking to file a divorce, we really just need them to have a working knowledge of the finances, of the debts, of obviously the marriage itself, which they certainly have experience and knowledge of, and just be able to explain the marriage holistically and talk through it. And first and foremost, above all else, they need to come with any questions they have. Like you mentioned, Josh, this is an opportunity for them to understand, to learn, to get educated on the process, and this consultation is when they need to have answered and ask any questions that they have.
All right, so we're about to go out to our first commercial break of the night. When we come back, I want to talk a little bit about how property is divided. That's a hot topic. It's an issue that we always get questions about when we do these shows of how is property going to be divided if we do go through a divorce. We're going to come back with Caleb in just a minute. Remember, as always, the show is always better when you are active in the show. Feel free to call us at 844-LAW-TALK, or you can always hit us up on the text. The text number is right there on your screen, and it'll be here. We'll be back in just a couple minutes after some commercials, and we'll talk about dividing property in divorce. We'll be right back. I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys. Welcome back into the show. We will be here for another 2 segments. We just finished our first segment with Caleb Faulkner related to divorce. Please always remember, you can always hit us up on social media if you've got questions throughout the week. And the lawyers of Hollis, Wright are here not just tonight, but throughout the week. You can call us at 844-LAW-TALK tonight if you've got issues associated with divorce or questions associated with divorce, or to the extent that you've got other legal-related issues. We have lawyers standing by right now for a free, off-air, confidential conversation, always available for you to answer those questions. Caleb, when we went out to break, we were talking a little bit about how property generally is divided pursuant to a divorce. That is a question we get all the time, is am I going to lose everything if I have to go through a divorce? Either someone has filed divorce against me or I'm thinking about it. Talk a little bit about just property division and how that generally works in Alabama.
Sure. So first off, the relevant question is, what is marital property? And barring a prenup or something else that would deal with it, typically what you have is any property that has been obtained during the marriage and has been utilized for the marriage. That's marital property. And there's certainly exceptions that you would need to discuss with an attorney, and obviously how the property is used versus how it was obtained. For instance, Josh, if you obtained a property via gift or inheritance during a marriage and it's not used commonly and regularly for the benefit of the marriage, then that may not be marital property. But the biggest thing is to first identify what is marital property. Once you identify marital property, you can look at how property may be divided. Alabama is an equitable division state. Now, equitable obviously doesn't mean equal. It may not be equal, but equitable is going to look at all facts and circumstances in the case, whether it be fault, whether it be ability to earn, a party's age, a party's position to get back to where they were financially. And after all of that, the court will make an equitable division of the property.
Talk for a moment related to the homestead or the home that a couple has with children, without children. Is the house guaranteed to be sold in a divorce, or is there a way that when the house is valued in relationship to other assets, one spouse can buy the other spouse out of that house? Just talk about that for a second.
It's really just going to depend on the specific situation and on the judge if you're in a trial. Obviously, if you're able to settle a divorce case and everybody's in agreement, you can certainly do things as far as buying the other party out, or simply maybe accounting for the value of the house when you make the division of the rest of the property.
Yeah.
However, if you're in front of a judge, obviously it's the judge's decision. And oftentimes, a lot of judges will take into consideration, if parties stipulate this is what we want to happen with the house. But often, a lot of judges, if there is no agreement, are going to simply order the house sold and divide the proceeds however the judge sees fit.
Having a lawyer through this process sounds super important to me.
Absolutely.
You need someone that is going to lead, guide, and direct you through the process, but also is going to be able to help you make good, non-emotional economic decisions at times.
That's exactly right.
Yeah.
That's of paramount importance.
Now, unquestionably, when children are involved, things take on a whole different kind of value, if you will. You guys are also involved in how to handle child support, child custody, those types of things.
Yes, we do. And obviously, like you mentioned, emotions run even higher when you're dealing with children, and obviously nobody wants their children to be a part of this. And so we always try to handle those situations in a way that always promotes the best interests of children and tries to maintain normalcy.
In general terms, are there presumptions that a minor child will stay with a mother, or kind of in general terms, how does that work?
Sure, there are no presumptions. Okay. There are various factors the court will look at. You know, one question we get asked a lot is, okay, what if the wife or the husband, whoever, has always been the primary caretaker for the children? What about that? Well, it's not dispositive. It can certainly be considered by the court, but it's not dispositive. In an initial custody determination, the court is simply going to be looking at how is the best interest of the children going to be served. And obviously all factors that would go into what's the best place for the child, what's the best scenario for the child.
How long is a child custody circumstances set for a child? Is it to a certain age?
Yes, it's until the age of majority, which is age 19 in Alabama, but it can certainly be modified thereafter.
We get a lot of questions about grandparents. Do grandparents, through child custody, do they still have a right to the child? I know that law's changed over the years. Kind of where does that stand right now?
There is a Grandparent Visitation Act as far as visitation grandparents can obtain with a child, intervene in a matter to get that visitation, but it's a very fact-specific area of the law. It's cases that we handle. It's certainly something that someone would need to get an attorney involved. It is not easy to prove, Josh.
Let's talk just for a second about college. I feel like that area of the law is has changed over the years. Is college taken into consideration when child custody issues and divorce issues are being resolved? For example, for a child in middle school or high school, college is coming. Do judges get involved in that, or is that something that is in between the spouses to make a judgment call how that's going to be handled?
If the child is a minority, then yes, absolutely, and certainly there are disputes as far as is a child going to attend public high school, private high school, and that's where legal custody of a child really comes in. Who has the authority to make those decisions, or is it a joint decision that both parties must decide together? However, if it's something you're talking about after the age of minority, if it's college, if it's costs of college, that's out of the court's hands.
Gotcha. All right, so we're getting ready to go to our second break of the night. When we come back, I'd like to talk a little bit about alimony and how that plays into what you do. And then I want to ask you some rapid fire questions related to child custody too. We're going to head out for our second break. We'll be back for one more segment here on The Attorneys. As always, the show is much better when you're involved. You can always call us, and the number is right there on your screen, 844-LAW-TALK, or text us tonight. We are always available too on social media and happy to answer questions that are presented to us through social media. We'll be back in just a minute here on the third segment of The Attorneys.
I'm attorney Carter Clay with Hollis, Wright Law Firm. If you've ever been involved in a civil lawsuit or been a witness to an accident, then you may have been asked to give deposition testimony. In this week's Legal 411, we are answering the question, what is a deposition and why am I being asked to give one? Depositions involve the process of a person giving under oath testimony that is outside of court. The person giving deposition testimony is referred to as the deponent. Depositions are taken in the presence of a court reporter, and the court reporter records the testimony. After the deposition, the attorneys for the parties received a typed transcript that contains all the questions that were asked by the attorneys, as well as the answers given by the deponent. The purpose of taking depositions is to ensure that the attorneys for the parties have a full and complete understanding of the events giving rise to the lawsuit, as well as an understanding of the testimony that they can expect to hear from witnesses at trial. Another reason an attorney might want to get deposition testimony is that it allows the attorneys to better prepare for trial and to develop a strategy for presenting the case to a judge or a jury. At trial, the deposition testimony can be used in several ways. First, if a witness on the stand deviates from the deposition testimony, an attorney can use the deposition to impeach the witness. Also, if a witness forgets certain facts or events, the deposition can be used to refresh the witness's recollection. Finally, in some instances when a witness simply cannot attend trial, the trial judge has the authority to allow the deposition testimony to be read to the jury. If you are a party to a lawsuit and are requested to give deposition testimony, your attorney will likely spend a significant amount of time preparing you for the deposition process to put you at ease and make you feel comfortable. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into The Attorneys. As always, we are available tonight. You can call us if you've got a question on this topic, the topic of divorce. If you've got a legal question related to other issues outside of tonight's topic, that's fine too. Don't be afraid to text us or hit us up on social media. Caleb, when we left off and we were rolling out to commercial, I wanted to talk a little bit about alimony and the status of that area of the law. It is uniquely different than what we've talked about so far in the child custody area and just general divorce. But talk a little bit about alimony and how that plays into this whole process.
So alimony is support, and the best way to think about it is kind of to replace the income as far as a dual income. And typically, there's many factors that you're going to look at. Typically, it's going to be a longer length marriage. Typically, a payor is going to have a higher income, usually a pretty good bit higher income than the payee. It certainly does not matter on which spouse it is, what gender it is. A wife can be paying a husband just like a husband can be paying a wife. However, the law has recently changed, and it's something that, again, you really need to speak to an attorney about. But typically, under 20 years, a judge could order alimony for up to the number of months married as of the filing of complaint for divorce. And over 20 years, it could be indefinite that would end upon cohabitation of the receiving party, remarriage of the receiving party, or death of either party.
Yeah, and I was going to ask you about that. Generally, is it understood that alimony ends when the spouse receiving the alimony gets remarried or cohabitates with someone else?
Yes,
okay.
It is. But one thing that a lot of people don't always understand is cohabitation. It's more than mere spending the night with somebody. It's more than just, staying over there once or twice a week. It truly really has to live to living together.
All right. Let me hit you rapid fire on some questions that we get a lot. Husband and wife get divorced. They have children. For work-related purposes, one of the spouses needs to move to another state. How do you handle that?
So there's an act called the Alabama Parent-Child Relationship Protection Act, which we call the Relocation Act, which states that anytime a parent is moving anyway, across the street, across the world, they must comply with this act. However, if the move is over 60 miles or across the state lines, then the other party is going to have a right to object, and that would be done by initiating another proceeding in the court, and the court would decide, but there is a presumption against the relocation.
That was going to take me to my next rapid fire question. If someone's not doing what they're supposed to, that they agreed to in their divorce decree, for example, or not paying child support the way that they're supposed to, or trying to move without approval of the other spouse, do you have the ability to go back to court to get the court involved, seek modifications, those types of things?
Absolutely. Child custody can be modified anytime until a child turns 19 and becomes an adult. And you do see that a lot, Josh. We see that time and time again where a divorce is ended, and whether it be 6 months later or 15 years later, you're back in court, there's issues, and you're resolving those issues.
It sounds to me like the court is willing to stay involved to make sure that their orders are enforced moving forward. Is that fair?
Absolutely correct.
Okay.
Yeah.
All right, so now let's talk about this. Someone agreed to a certain amount of child support, and the court issued its order, but there's been a change in circumstance. For example, that person's income has been cut in half, or maybe they became disabled for one reason or another. What do they do in those circumstances?
Certainly file a modification. However, a court is typically going to look with more scrutiny in situations where a party did agree to the amount, especially if there hasn't been a lot of change in circumstances since then, and especially when it was very recent. If it was, 6 months ago versus 15 years ago.
Do you find people come to you at times, they try to handle this on their own, and they recognize, hey, I need a lawyer?
Yes.
What's your recommendation to them?
Go find a lawyer. Start with a lawyer from the beginning.
We've got about a minute left tonight. Just a final couple, 15-second final thought. Give me a final thought of what you'd like to just kind of tell the viewing audience.
Divorce is a tough time. It's a tough process. We see really good people during tough times in their lives and always want to help during those times. The best thing you can do is find an attorney that you trust, that you have a good rapport with, and allow that attorney to guide you through this tough process.
Caleb, you've done a great job. You're super knowledgeable in this area. It's why we bring the experts on in these circumstances. And for our audience watching tonight, we've been honored for 11 years to be here on the air with you. We're going to be here next week. You can hit us up during the week if you need help. We'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.